So, when filing a patent application, we also are often asked the question, should we internationally file this application outside the US? And that's often a very complicated question to answer. One of the first considerations is, can we actually foreign file at all? And people have got to keep in mind that the US is somewhat unique in that it has this 1-year grace period in which you can file a patent application, within 1 year of publicly disclosing that invention. Most other major countries in the world don't have that grace period. So if we are filing an application on a concept that was released within the past year, we typically cannot, the question of foreign filing does not arise. It's moot. We can't foreign file. If our base application is being filed after the date on which that inventive concept was publicly released, foreign filing is not an option. On the other hand, let's just assume that our base US application is being filed on a concept that has not been publicly released. Then foreign filing remains an option, and that's where we take into account other factors. The other factors typically are, number one, business reasons. There we often want to protect our invention in a market where there's a very important market for that particular concept, and that's very best answered by business people. Within a company, they will know, for example, is this feature going to be incorporated into a product that is going to be sold in Europe, or do we have a market in Europe? Do we even care if someone's infringing or copying our technology in Europe? And if it's not a big market for us, quite frankly, we may not care. The other, I firstly classify the reasons as kind of business reasons. You look at market, where are your competitors located, where are your competitors' factories located, where are their development centers located. And for software, we're also often looking, where are your competitors' servers located. A lot of companies have servers located in Ireland, which makes Ireland an interesting prospect for, or an interesting option for foreign filing. So that's the kind of the business aspect of it. Related to that is also the legal aspect, which is certain foreign jurisdictions are friendly towards software patents, and some are not. Brazil, very unfriendly towards software patents. It's quite frankly harder to get a software patent in Europe and China than some other foreign jurisdictions. So you may or may not want to file over there. And then also beyond the business legal criteria, there's also what we call the cost criteria. Some jurisdictions are very expensive to file in. Korea, Japan, Europe are very costly, whereas certain other jurisdictions, Australia, Canada, are cheaper. So in a nutshell, 3 things to consider: business criteria, legal criteria, and cost criteria.